Nigel Gilroy, my colleague, is an intellectual property specialist, and although you haven't asked any questions about it, we thought it sufficiently important for Nigel to introduce very briefly a very large area. So just a very summary of the law relating to intellectual property, but I hope what he says will spark some questions. Davenport Lyons is an established West End firm. We've got 49 partners. We cover a large number of different areas of commercial life in the West End, but media is where the heart beats. We do every aspect of media work: publishing, music, film, TV, advertising, the lot. So, may I introduce Nigel?
Thanks, Roger. I'm just going to talk very briefly about copyright this evening. I'm not planning to go into it in too much detail. Some of you will know most of what I'm going to say, and some of you won't. But I hope just by giving a brief overview, it might trigger some interest, and some of you might want to ask some questions at the end about any specific areas that might be relevant to anything that you guys got going on. Copyright is it is what it says. It protects your investment in your creative efforts, whether you're a publisher, a writer, architects, anyone who really creates sort of artistic things that are intangible. Broadly speaking, copyright will protect them. It's been around for a long time, about 300 years. I think it came about because William Caxton invented the printing press, and it's been around ever since. And it was introduced by the Statute of Anne in 1708. So they've had 300 years to try and get it right. For those of you in this room, probably the most important things that copyright will protect are the text and pictures and layouts in magazines, maybe architects, plans, models, that sort of thing. Text and photographs in particular are protected for 70 years. So it's 70 years after the person who created it dies. So it's a fairly long term of protection. It's intended to be handed on and to be for the benefit of people's heirs. You don't have copyright in the names of your publications or your business name or anything like that. That would be protected by trademarks. And those of you who have valuable trademarks that aren't protected, I suggest you get them protected. But what you do have copyright in, relevant to your name, is the sort of banner, or the headline banner. So if your name is set out in a particular stylized fashion, then that would have copyright in it as an artistic work. And there was a case some years ago now, I think, relating to the Sun, where someone alleged, well, there's no copyright in the name The Sun for a magazine, but because the banner itself looked a bit like the Sun logo, they managed to prevent them from using it. So you do have protection in that. There are some related rights that you get protection from. Rights in things like directories and customer lists and so on, or circulation details and so on, which are valuable to your business, may not attract copyright because they're not sufficiently inventive, if you like. But they would be protected, probably be protected by a database right. That doesn't get 70 years protection, but it's nevertheless valuable, and because, of course, client lists and the like probably have a shorter term of currency in terms of their value, then the shorter term of protection isn't so important. I think probably finally the other type of protection that all of you may be interested in is the protection in the layout of a magazine itself, which is protected as what's called a typographical arrangement, and that's probably the work that most of your sort of sub-editors are doing, which is sort of putting magazines and other publications together. And if that is in a sort of format that's recognised and is standardised, then that will attract copyright, and people can't take advantage of that. But it's only protected for 25 years, and again, not 70 years. So who owns the copyright? Well, generally the person who owns it is the person who created it. It's the author who owns copyright, unless, and there's one exception, and one exception only to that, that person creates the work in the course of their employment. So anyone who's under a standard employment contract will not own the product of the fruits of their labour. it'll belong to their employer. This is probably quite important to any publishers in the room who will probably be using freelance photographers, journalists and the like. If you commission a freelancer to go out and do some work for you, that the copyright in that will vest in him, and unless you take an assignment of it from him or her, then you're only going to have a very limited license for the use that you actually commission them to go out and do the work for. So, for example, if you wanted to, you said, can you go out and write an article for next week's publication? They gave you the article, you put it in next week's publication, and then decided you wanted to put it up on the internet, or you wanted to use it in the sort of annual report or whatever. You may not be able to do that unless you'd either got a license to do pretty much what you wanted with it, or had taken an assignment of it in return for the payment that you've made for it. But people do get caught out a lot on that, and it's happened a lot in relation to architects who have been commissioned to design buildings or houses, and then builders have then trotted out the design ad infinitum and built sort of swathes of buildings to the same design, and the architects have only been paid for the one. And of course the architects have got upset, and this issue has been looked at by the courts a lot, particularly in relation to that. So ownership is important, and you'll have gathered from what I've just said that knowing what you've got is also important. So have you got an assignment of the copyright? Do you own it? Or have you just got a license to use it? A license to use it will be for, it basically means that what it says, that the guy who created it still owns it, and the person who commissioned it has rights to certain uses which will be defined by the terms of the license. So if you are taking something on a license, make sure that the license covers the uses that you want it to cover, because if it doesn't, you could find yourself on the end of a claim for infringement, which in practical terms means that the person who did the work is going to come back to you and ask you for some more money, because they say, that particular use wasn't covered. So it's very important, and it can end up costing money if you get it wrong. The sort of things that you're not allowed to do with a copyright work, and the things it protects against, are probably fairly straightforward to understand. You can't copy the work, you can't communicate it to the public, you can't rent it or lend it to somebody, you can't adapt it, which can be tricky. So you couldn't technically, if you didn't have a license that included a right to adapt, or you didn't own it, then, for example, editing an article so it fitted in a magazine might be copyright infringement. So that's something to watch out for. Or indeed, shrinking a picture to fit in a magazine might constitute an adaptation. So you have to be careful again that to avoid infringing copyright, that you're clear about what you can do with it. And obviously, the best way to do that is to own it rather than to have a license of it. There are a few things that you can do which might be infringing, which probably the most relevant one to this audience is the fact that you can take photographs of copyright works such as buildings and publish them in a magazine, and as long as they're already in the public domain or on public display. So, for example, if you wanted to put a picture of the Gherkin, as long as it was your picture, if you wanted to take a picture of the Gherkin and put it on the front of your magazine, you could do that, because although the Gherkin is an artistic work, probably vesting in either the owners of the Gherkin or the architects who designed it, because it's on public display, you can take a picture of that and use it, and you're not infringing copyright. So that's probably the main exception to infringement that applies here. And that's about as lightning a whistle-stop tour of copyright as I
That was brilliantly done there, St. Nigel.